Thank you, KSI, for inviting me to this conference. Definitely, we had a very interesting and informative session throughout the day. The coverage from morning until just now was full of ideas, full of challenges. We heard from Dr. Jamila that we should be looking at COVID perhaps from beyond what we are looking at now, and we have to take into the environment into consideration. We should also be addressing ESG as well as SDG concerns if we really want to minimize the impact of pandemic crisis that is likely to impact not only Malaysia but perhaps the world as well. And I'm sure for many of you, in times of change and turbulence, we get to learn many new terms. For one, I think all of us starts to understand that Zoom is not getting from one place to another. No, it's actually to be sitting in front of your devices. We have to learn very quickly to adapt to online technology, such as Google Meet, Microsoft Teams, which all take on a whole new meaning. MySejahtera, MCO, RMCO, and EMCO, and so on. So it goes to show that the humanity, right, has great capacity, has great agility, has great flexibility to adapt to situation as and when it arises. And it goes to show that if collectively and collaboratively, if we are able to come together united, irrespective of gender, of race, of political beliefs, and so on, we stand a very good chance to actually recover, and hopefully we are able to thrive and pray hard that the situation will get back to normal. So this afternoon, I'm extremely pleased to have with me 4 thought leaders in their own right. I had the privilege of meeting a few of them on previous speaking occasions. We have Dato' Shamsuddin, right? I am sure you will be very enlightened about what he has to share with regard to the Employment Act. Then we will have Shireen, who will be talking about agility in organization, how we as either employers or even as HR leaders, practitioners, addresses the issue of agility. I think in the earlier session you heard from Mr. Gaurava from McKinsey. Literally almost all his other slides is actually talking about agility. So hopefully Shireen will be able to give us a little bit more insights and best practices of how can we really get agility to be an organization. How can we put in place to transform the organization to become an agile organization, to be able to adapt much more comfortably in times of change. And I will have Donovan to share 2 very interesting legal concepts of force majeure and frustration. Is there in law any real technical differences between these two, and how should these 2 principles really be addressed, from the context or from the perspective of employers and even perhaps employee. And last but not least, Ms. Salva will be sharing her thoughts on retrenchment, layoff, closure of business. Is there any obligation that the business owners, needs to address or take care of to avoid any kind of costly litigation, so-called loss of credibility and so on. Because when we talk about legalities, right, we probably are fully aware that in the discharge of our legal obligation, there's really little room, or I would say no room for errors, right, for trial and error, because it has to be something that the stakeholders really need to understand the interpretation and how to go about it to avoid any negativity outcomes based on their decision if these compliances or adhering to regulatory requirements are not followed through. So hopefully, you'll get to hear some insights from our two legal experts here, and I'm sure you may have questions on the point of law, and this will be a great opportunity, a great platform for you to raise questions, to my fellow panelists. So without further ado, I would like to invite Shireen to share her thoughts on agility, and let's warmly welcome Ms. Shireen. Right.
Thank you, Henry. If you don't mind, I'll just sit here because I'm very short. If I go to the podium, people won't be able to see me. Good afternoon, everyone. Thank you. Hi, nice to see you again. Okay, so I'm going to try to talk about agility and agile workforce in the context of a legal framework. So that's going to be quite interesting. How do we actually look at a new way of managing our workforce where there's greater flexibility, it is more agile, and the gig economy being the economic construct that sort of supports that within the laws of the country, and Dato will talk a little bit about that, and within some of the legal frameworks that the other two esteemed panelists will talk about. So let me just give you a context of the larger economic construct, because I really like to start from a macro view. So when we look at all the disruptions that's happening, globally, in Malaysia, in the region, you see four sort of mega trends. And it starts with the, I would like to start with the sharing economy, where that with issues of sustainability, issues of environmental fragility, we look at products and services and how we ensure that what we produce is well consumed. We produce within what is needed, and then the waste or the disposal of the product or the life cycle of the product is being well managed. So that's the the circular economy. The next bit is the digital economy, and we know this, and we are already right smack in the very sort of extreme form of how digital economy is now driving the way we work, the way we live. Without the kind of devices or the connectivity that we have today, it will be difficult for us to do contact tracing. It will be difficult for us to actually look at, how do we manage the pandemic at a national level. Now we're used to using codes for our MySejahtera apps and things like that, right? So the digital economy kind of then pushes that adoption of technology in a greater way because it has now societal impact. The other bit that we look at very closely is the sharing economy. So I started with the circular economy, the digital economy, then the sharing economy, which is what we are all used to these days. So obviously if you jump into a Grab car, that's a sharing economy. If you, go on to Airbnb to sort of, find a place to stay while you are holidaying, that you're staying in somebody else's house. So the sharing economy becomes one construct that kind of, support the digital economy, because then people can reach out and sort of look at different options that they have. Yeah. So the thinking around gig economy, which is the fourth part of the economic construct, is that then, when you are sharing cars, you're sharing homes, you can actually share your talent. So that's where it starts to get very interesting in a way that, with the digital economy and all this disruptive sort of, economic push, we see that people are now liberated. We don't work in conventional settings anymore, and the future will look like that. We are already living in it because we use technology to work. We are so, connected via Zoom and all that. And you're right, we thought Zoom was moving from one point to another, but it's actually interacting with other people. So that becomes the norm. So how do we think about that in a way that, fulfills the work requirements or the things that you need to do, but also looking at different opportunities within the gig economy. And we talked about it a little bit earlier today as well. Some people are still not bought on into the trend, they say, but it's really here. It's not going to go away. How do we work around that, and looking at agility and looking at a new way of our workforce? Because the days of us working in an organization for 10, 15 years is kind of going in a sunset phase. People are now looking at projects. People are looking at, being associated to their expertise and their specialty rather than being associated to an organization. So that's already, something that we are living today. And some of the examples that I have are, obviously in other parts of the world where the fractional work, I like to call it fractional work, becomes more acceptable, where, the data shows that, and I spoke about this earlier, just repeat it again, I repeat it, in 2018 it says that, 56% of companies already say that today they need to look at independent workers with different kind of skill sets to complement the workforce that they have today, right? Because they need to change their strategy, they need to pivot, they need to look at new businesses. And if you are built on a traditional business and you want to move forward to a growth business that has a completely different business model and all that, you really don't have the kind of talent in your organization that can do that. So the fractional work for people who are, experts or people who have deep experiences then becomes a good value proposition for the company, because then they get the person on board, do the project, get it done, and then move on, right? So that's where fractional work comes, and it's a value proposition for a lot of companies because there is a cost reduction element. There are a lot of research out there. You get cost reduction of about 7%. This is a McKinsey report. And why do you have cost reduction? Because the person is already skilled to do that task. You don't have to, invest in a recruitment process that takes too long, or even, having to train the person for the skills, because you need to pivot very quickly. So there's 7% reduction because you get the talent in and they do the job and they are skilled for it. There's also 9% in terms of productivity. Same principle. Because the person is skilled to do that work, then they get the job done, the productivity level of the organization increases. So where the sweet spot of this gig economy, especially for fractional work for professionals, is that companies have got a need for a particular role that is not long-term. They need to get that project done, and they're looking for that kind of skilled labor or skilled expertise. On the flip side of the supply side, there are a lot of more professionals now doing fractional work because they require the flexibility, because they're an expert in their field, and really their skill sets is needed for that point of time. And when the project is done in that organization, there's really no need for them to be in that role for long term. So that's where, the two sort of supply and demand meets very nicely, because the company has got that role, it's short term, it's required, the skills are required, and the person can fill it at that time and that point of time, and it's done. So a lot of that is already here being practiced in some of our organizations. The MNCs especially look at the agile workforce model as, like I said earlier, cost reduction, increasing productivity, and they engage the talent at the skills level that's required. And at the end of the day, for the person who does the gig, because you are engaged in that piece of work that you are skilled at, your level of satisfaction is higher. We all have to agree to the fact that sometimes we get stuck in a job that we really don't like. And sometimes we're not even skilled to do, but we fill that box. So we really need to think of a new construct of how talent is engaged in an organization and how companies now need to open up those roles for fractional work that then argues the point of efficiency, productivity, and of course, cost optimization. So that's my opening, and I'm happy to pass it on to Dato'. Dato' is going to talk about the legal part. I'm talking about the opportunities part because I'm always the glass half full person. There's a lot of things that we can do to change. While we're in COVID, post-COVID, we have to find a new way of work that, you know, embraces, you know, technology, that drives our passion, and then it uplifts the, you know, overall productivity of our talent. Thank you very much.
Thank you, Shireen. Right. So moving on, we'll have Dato' Shamsuddin to share his insights with us pertaining to the Employment Act and other key updates on the employment issues happening even as we are speaking about it. Let's give Dato' a big round of applause. Okay, thank you.
Thank you very much, Doctor and fellow panelists. Thank you very much for inviting me to be here. I'm not going to talk so much about legal aspects. I don't practice anymore for a long time. Yeah? Ms. Selva just reminded me that she did her first case with me, yeah, in one of the dismissal cases involving telecoms matter. And I think let Mr. Donovan and Ms. Selva to do all the legal talking. But I'm going to share with you now on the general aspects of the current labor market situation amidst COVID-19. Yeah. How do I process this one? Yes. So this particularly the survey done by, not by MEF, but by DOSM, Department of Statistics Malaysia, to see what is the financial strength of Malaysian companies. We can see that close to 68% during that period of MCO don't have any form of revenue, no sales, no production during that period. Yeah. Only about 12.3% say yes, they have something on that, some revenue, yeah, from based on online sales, thing like that. And of course, some of them are allowed to operate during that period, especially if they are on essential services, yeah. And of course, important part is that when we talk about the source of finance itself, how do they finance their operation? How can they survive during that period? Most of them say that, no, they use their own finances. Close to 69% of those companies say that there's the only mean for them to survive during that period. And of course, you know, some of them also have loans from other institutions, and that's how they survive during that period. And of course, important thing, ladies and gentlemen, for us to see this, you know, how actually they fare during this period, how long actually they can withstand this pressure. Yeah? Of course, most of them say that they require more than 6 months to recover. Yeah? And I would say that in that kind of situation, of course, 2020 means that it's very difficult for them to make any move to recover their businesses. So just trying to sustain themselves. Some of them say that require less than 6 months. But the last part is interesting, ladies and gentlemen. They say that about 1.9% of the companies say that they're not going to recover at all. They are going to die, basically. Yeah? And what is the impact of that? if you translate into numbers. In Malaysia, there are about 800,000 registered employers, registered and active employers. Of course, you talk about registered entities is more than 1 million, but the one that is active in contributing EPF contributions are about 800,000. So 1.9% of 800,000 is basically 15,200 entities. Don't talk about 1,000 employees, just talk about 10 employees for each of the company that's not able to survive. Then you would have about 152,000 people losing their job. Yeah. So that I think is important because the government is thinking that the figures that is that was floated by MIR, for example, 2.4 million are going to lose their job. Yeah. SMEs say that more than 1 million will lose their job. MEF say that possibly it is double-digit unemployment this year. Yeah. Of course, it is yet to be seen how all this thing goes. Yeah. And of course, as far as retrenchment figures are concerned, the figures from the Labour Department, I'm sure later on our legal expert will talk about PK form, thing like that, but the Labour Department that manages the PK form, when employees retrench, say that retrenchment as at to date, current date, is less than 55,000. Yeah. Whereas in EIS, the figures actually is more than 73,000 at current date. So a lot of discrepancy as far as figures are concerned. But what is important is that the MB of Johor say that, okay, look, in Johor state alone, there will be no more than 160,000 people that lost their job. Yeah. So you can see what is the impact really as far as COVID-19 is concerned. Yeah. And of course, this is just the unemployment figures. Yeah. The height was when we talked about in the country, there were about 5.3% unemployment. Yes, more than 800,000 people unemployed. That was in May. Yeah. But fantastic, ladies and gentlemen. In June, they say that the unemployment figure dropped to 4.9%. Yeah. So I'm not sure how people get employed so fast during that period, but I leave it to you to actually decipher this, whether you would accept these figures at face value. Just to share with you, I don't believe these figures, basically. Yeah. And of course, when we're talking about these are in numbers, 826,000 in May, and it dropped down to 773,000, as if employers are busy recruiting during that period. Yeah. And of course, Shirin do talk about the new normal. But what is interesting, ladies and gentlemen, is that we are expected to operate in new normal. But what is the environment that we are operating? We are operating under the old normal. So the old normal is expected to support the new normal, which we say that, even as MEF, I always say to the media that that is not going to work. Because basically, under the new normal, obviously you require new norms to actually support the operation of new normal. And this means that there is a need to be more flexible. But are we actually getting more flexible, ladies and gentlemen? On Friday last week, the government gazetted the enhanced regulation on housing and amenities. As employers, you must provide at least 4 inches thick mattress. And you know how mattress operate? After 2 or 3 days, the 4 inches will go to 3.45 inches. Then you are breaching the law. You can be penalized 50,000 ringgit for each offense. And this is exactly the kind of thing that MEF had always been telling the government, that we cannot micromanage the private sector. You cannot tell us how thick is going to be the mattress or how big is going to be the locker. And that is going to kill off industries. And I would say that investors may not like that kind of prescriptive regulation being imposed on the employers. So I would say that we actually, MEF is trying to say that, okay, look, now we are talking about new normal. Why don't we just talk about how can we make our labor laws more flexible? But unfortunately, I think that kind of thing is not being accepted by the government. Yeah. And of course, the question is that when we have this new normal, I think this Syrian had touched about this, how do we actually now try to operate within the new environment? Yeah, of course, we had been trying to have a lot of webinars, conferences, online, things like that. But when you're actually engrossed in your talk, basically, then the message appears in your computer, your connection is not that stable. Yeah. So that is how we have. They say that we have connectivity, but the connectivity is a bit wanting. Yeah. They say that we have 5G, but then when we check our connection, it is 2.4, 2.3G only. But you pay most expensive. But when we talk to the government on this, they say, no, this has been taken care of by the telcos. Of course, this is with due respect to the telcos, thing like that. Yeah? And of course, the other thing is that, of course, we of course try to convince the government that when we talk about the new normal, we need to talk about the new enabling legislation, and we of course need to move forward very fast. But unfortunately, all these kind of things are not being taken up by the government. Yeah, and of course, the most important part, ladies and gentlemen, when the government announced the MCO on 17 March. They come up with a statement to say that you as employers must pay full wages and full allowances to the employees during the MCO. So the question is that whether we are really obliged to do that. Perhaps the legal expert can talk about it later. But to me, in my simple mind, if there is no work, there shouldn't be any pay. But of course, that may be too harsh to the employee concerned. And of course, we can be guided by what had been decided in the Goodyear case to say that in that kind of situation, perhaps employees should be paid 50% of the wages when they're not required to come to work at all. Okay? But to expect employees to pay full wages and full allowances is, I think, making the employers die faster. Yeah? And of course, the thing is that, these are some of the things that later on, when the government talk about Panjana scheme, thing like that, yes, you employers can negotiate with the employees, with the union, about pay cut, about shorter working days, shorter working week, thing like that. But I would say, ladies and gentlemen, damage had been done already because the government had made a pronouncement to say that wages and allowances are to be paid in full during the MCO period, and some of the employees even challenge the employers when they are allowed to work by MITI to say that, no, why should I come to work? I'm now allowed to just be at home and receive my full wages, full allowances. And if you want me to come to work, pay extra. Then will I come to work. If not, I'm not going to come to work. Yeah. And that is the situation. Of course, also interesting, ladies and gentlemen, I believe you had read this one of the latest survey. 90% of the employees say that they prefer not to work in the office. Yeah. But of course, my response to that is very simple. It's not the employee's call, it is the employer's call. It's employers decide where you should work. Not the employee dictating to the employer where the employee should work during a certain period. Yeah. And of course, this is for, if you're looking at the latest, one of the latest bill that was introduced in Parliament is to address this issue about the obligation arising from MCO. Possibly Donovan and Selva will talk more about this. But what is important here is that just on the IR part, we need to recognize that during this period of MCO and CMCO, and also perhaps the RMCO, the government say that as far as the 60 days is concerned, it is not actually operating. In the sense that it is frozen during that period, and even if the employee take more than 60 days to file their case under Section 20, it is still acceptable as far as the authorities are concerned. Yeah, and of course, what we actually had suggested to the government was to say that, no, we should actually allow employers a lot more flexibilities. Introduce provision in the IR Act to say that if the company terminate or retrench the employee during the MCO, RMCO, CMCO, then don't allow them to use Section 20. Yeah? And of course, for some parts of the Employment Act, especially Part 12, then perhaps a lot of flexibility has to be given to the employers on that. Yeah? But of course, I think just to share with the participants here, ladies and gentlemen, even for us to see the minister is very difficult, because the minister seems to say that his attendance in Parliament is compulsory, yeah, and he cannot attend to other matters during the period where Parliament is in session. Yeah. And of course, this is something like what had been also being said in Parliament about closures of company. Yeah, more than 4,500, 42 companies had closed during that period of CMCO. But the minister or the deputy minister say, don't worry, only 4,500 ceased business, but more than 82,000 new companies were registered during that period. But the fact remains, ladies and gentlemen, you can register companies, but you may not do any single business, basically. I think that there is a fact that perhaps the minister failed to address, yeah. And of course, it's just the figures that I think I had said earlier. Is the time up? Yes. Just perhaps I just want to conclude, yeah. And of course, it's just to share some of the latest retrenchment figures. But what is important is basically, ladies and gentlemen, I just want to actually talk a bit about the employment laws, yeah, the cost to the employers. It's just to say that, the kind of cost that is being imposed on employers in the event the government proceed with the proposed amendments to the Employment Act, the Sabah Labour Ordinance, and the Sarawak Labour Ordinance. But I think as far as Sabah and Sarawak Labour Ordinances are concerned, I think the government is in a bit of a jam, in the sense that the state government of Sabah and Sarawak say they want actually to have more control over the labour ordinances. So that is, I think, the part that I think the federal government is trying to still negotiate with the state governments on how best to handle the situation. Yeah. And of course, what is important also is that there is a move to say that 48 hours work per week is too long. Yeah, when the ILO Convention on Working Hours still talk about 48 hours, so they wanted to reduce the working hours, and of course, the net impact is there already as far as overtime payments are concerned. And of course, you're talking also about other costs, maternity leave, of course, with due respect to the females here. Yeah, of course, they wanted to have 90 days or 99 days, yeah, rather than 90 days. But see, the impact can be very serious. And of course, when the female want to have higher maternity leave, the male also say, I want to have paternity leave, yeah, as part of the entitlement under the law. And of course, the other part is on the amendment to the IR Act. Yeah, we know that it was passed by Parliament. Yeah. Dewan Rakyat, Dewan Negara, and also being signed by the Agong. It was gazetted on 20th February, yeah? But there is no date of implementation given there. And I hope the government will not give any date of implementation at all, because the consequences of implementing those amendments can be very, very serious to the industrial relation environment in the country. I think with that, please allow me to just stop here for the time being. Thank you very much.
Right. Thank you, Dato'. Right. For good insights on what are the cost implications, should there be any major amendments to the employment legislation. So, so Donovan will share his thoughts on the doctrine of frustration, on force majeure, and how this two legal concepts can also, what are the implications for employers and business owners, right? So, Donovan?
All right. Thank you, Dr. Henry, and good afternoon, my fellow panelists and the audience here today. I think just before we started, I think Shireen asked me to try to make this session more exciting because it's the last session. She asked me to share some jokes, but unfortunately, my profession is not one that's very humorous. So I don't have any jokes for you, but I think what I would share with you as an opening remark is similar to Datuk, an interesting statistic that I found. Okay, so according to Google Trends, if you look at Google, you can actually identify search activity throughout the world, and you can even narrow it down in Malaysia. So what I thought was interesting before I prepared for this talk today was I looked at what is the activity like for people in Malaysia when they search about force majeure. Okay, because that's the topic I'm going to talk about. And what I found out was that based on the chart, the search activity for the phrase force majeure peaked on the week of March 15 to March 21st, 2020. And it recorded 4 times more search activity than the month before. So in February, people weren't really searching about force majeure, but on March 15 that week, it recorded 4 times as much. And I think we all know because March 18 was a very memorable day for all of us. It was the start of the MCO, and I think that triggered a lot of response from businesses. Really, what do we do now that we are prevented from operating if we are not essential business? And then, as we all are in now, the MCO has extended into so many hybrids. It became the CMCO, now RMCO, which has been extended to December. I don't know what other initials will come up, okay, in January 2021. So, to me, search activity always reflects what is the public thinking about, what are key issues. All right, so the fact that force majeure has popped up 4 times as much in March, and the trend continued. It didn't peak as much after that, but the search rate was still a lot higher than it was back in February. So it shows that businesses have been thinking a lot about what is force majeure. So now from a legal perspective, I'll share a little bit about what it means. Okay, force majeure sounds maybe very complicated, sounds like a very nice phrase. Okay, if you're not in legal practice, it sounds very nice to say, all right? But actually, what does it mean? Okay, force majeure is a clause typically found in contracts which provides the effects if something happens or circumstances happen that are beyond your control, unforeseeable, that would make it impossible for you to perform the contract as you had agreed, or make it something, let's say, radically different from what you had agreed to at the start. And the force majeure clause, depending on how it's drafted, will usually provide for consequences to parties if that situation occurs. Typically, it would say something like, in the event of these force majeure events, parties are suspended from fulfilling their obligations under the contract. That means they no longer need to comply with what has happened, what they promised to do in their contract until, let's say, some other event takes place, like the force majeure event has been declared over, or they take some other corrective measures to address the force majeure event. So, if you have seen force majeure clauses before, you will notice that they often describe what is it considered a force majeure event. You will typically see things like war, riot, act of God sometimes, and government action. So these are the common types of things that you see. It's, for example, where, let's say, you have a contract to do a certain thing, but the government suddenly passes a law which says that this thing is now illegal. So typically then the force majeure contract will activate, the force majeure clause will activate to say that, okay, you're no longer required to comply with your obligations under the contract because it is now illegal. And, or the government has prevented you from doing it or making it impossible. So there's no repercussion in that sense. You can't be sued for breach. Okay, but now we're in COVID-19. Okay, we're dealing with the issue of COVID-19. What is COVID-19? It is now been declared a pandemic by WHO. And does the force majeure clause that you want to invoke, does it refer to this situation? Sometimes you will see it. You will see the word epidemic. You'll see the word pandemic. Or you may see the word something like global illness or something like that. So if your force majeure clause does reference to something that could apply to COVID-19, then okay, first ground, maybe you've met it. All right, that you can now start looking at whether you can actually invoke the force majeure clause. If you don't have those words, like you don't have the word epidemic, you don't have the word pandemic, you don't use the word illness, okay? Sometimes lawyers, we tend to be a little bit conservative, then we'll write a catch-all at the end that says like all other related matters or all other related circumstances. So then the question becomes is, can you go and look at things like that when it's very general? So interestingly enough, I think I was looking at some decisions on this. There was a court case which says that things like, I think, depression in the economy or recession, you can't really use it to fall under a general category of force majeure. So if you're saying that COVID-19 has caused the global economy to be affected, my business is now bad, so I'm now invoking force majeure, quite possibly you may not be able to invoke it in this situation if you're trying to rely under that specific wording of general circumstances. Because the court in that case, I think, held that, depression in the economy, changes in the economy, recession, they are all part of normal business risks, which should be foreseeable in that sense. And it's not meant to be part of this force majeure, which is covering things like earthquake, the pandemic, like that literal kind of meaning. So look at your clauses first, whether you actually have a specific wording inside. In an employment context, because we're here talking about, the workplace, another interesting thing is how many of employment contracts actually have a force majeure clause. Okay, I think we were discussing it now among the panelists as well. I personally don't see it a lot. Maybe Salva, you can comment later how common you see it. But for me, I rarely see it in letter of appointments. I don't really see it in contracts of employment. Sometimes it's there. If it's a standard template that they've used from other jurisdictions and whatnot, who are maybe have the tendency to have very thick and very verbose kind of employment agreements. But for the typical ones we have, I think we can look back at your own contract. Most of you would be employees as well, or even business owners. You would see that I think most of the time it will just cover like your remuneration, annual leave, termination, notice of termination, probation. At the end also, if there are boilerplates, it will usually be that this is governed by the law of Malaysia. There's some severability clauses, and amendments must be in writing, all that. But there really isn't going to be a high chance that there's a clause there. So in the employment context, if you don't have a force majeure clause, you can't even think about invoking it. So what's the possibility of us as employers using that? I think that's really the first issue. Secondly, if your employment contracts don't have the clause, does that mean you are completely left out? Okay, there's no other remedy. There's another concept which Dr. Henry has touched on just now, which is the concept of frustration. Okay, frustration, what does it mean? Okay, frustration has two meanings. The first meaning is feeling, which is what I feel when I go to court sometimes. That's frustration. The second one is frustration of contract, which is, there's a legal definition. I don't remember it offhand because my memory is not so good, but essentially under the Contracts Act, okay, there is a provision which says that if something along the lines that if your contract becomes impossible to be performed, okay, after it has been entered into, okay, you are in a way discharged from your obligation, similar to force majeure. So force majeure is basically both parties agreeing to the concept of frustration. In other words, if I can simplify it. Okay, so even if you don't have a clause called force majeure, you can still look at whether the possibility of frustration applies. But this is again the tricky part, because in an employment context, COVID-19, as you all know, is very novel. Okay, we haven't seen a pandemic like this, for a long time. Okay, and I think all the cases that we had where the High Court or the superior courts have decided on frustration in an employment context, they don't deal with the situation of a pandemic. What we've seen previously is that frustration typically will apply in a situation involving medical illness. Okay? For example, where your employee has been rendered medically unfit such that they are really no longer able to perform the work that you have engaged them to do for a prolonged period of time, which basically means that the person has become medically unfit to work. Right? In that situation, there is a possibility for you to say your contract has been discharged on the basis of frustration because he can no longer do the thing that I asked him to do. Okay, and it has been allowed in situations where, for example, a person has been rendered chronically or terminally ill for a long period of time, and they take like 1 year's worth of MC and unpaid leave, 2 years, still haven't recovered, no prospects. But if you look at it in that context, COVID, I don't think is applicable. All right, because I think as we've seen, COVID is an illness that, yes, it's serious, but there's recovery. People are not disabled for like 1 year from working. When they recover, most of the time they can, of course they have long-term symptoms, maybe later, but they generally can go back to work. And it's not for like 1 or 2 years. So using frustration, I think, to address, let's say, discharge of employees may not be suitable as well. So I think if you're talking about the two concepts of, force majeure and frustration due to COVID, and how does it affect employees, if you're talking about how your business has been affected by COVID, perhaps a better and more relevant avenue is for companies to look at the possibility of, let's say, downsizing, whether there's a genuine redundancy, which Selva will talk about later, and rather than, trying to invoke this type of clauses, especially when, if you go to industrial court, they are not really strictly bound by contractual principles. They are a court of equity and good conscience, which means that they will look at the situation as a whole, whether it's fair to employees or not. And they're not going to go on a technical legal argument about whether you fall within the clause or not. So I think that's what I have to share on these two topics, and I'm happy to pass it on to Selva to talk about the other issues. Thank you.
Right. Thank you, Donovan, for that clarification on force majeure and frustration. I think it's very clear on the invocation and on the applicability in the context of employment. So moving on to Ms. Selva, she will share her thoughts on retrenchment and closure of business. So over to you, Ms. Selva.
Thank you. Can you all hear me? Yeah. Right. Good afternoon, everyone. I'm actually very delighted to be here after months and months of conducting webinars. It's a real breath of fresh air to be in the same room with people and, have face-to-face interactions. But I have the unenviable position of being the last speaker in the last session. And I'm less humorous than Donovan, perhaps because I've been a lawyer for even longer. But I'm going to try my best. So, we heard about agility, flexibility, Shireen is talking about agility, Datuk Shamsuddin wants flexibility for businesses, and we all know we are in the new normal. Unfortunately, or fortunately, depending, where you are, our laws are still the same, right? Our lives may have turned upside down in the past 6 months, but our laws haven't changed. Yes, there are some new bills going through Parliament at the moment, but even then, they don't really bring about major changes. So what we have to do really is operate in the new norm, but within the old framework. And we have to try to make the best of things. Now, I'm not going to get into the nitty-gritties of law. I know you don't need to hear that, but let's talk about the practical issues instead. Now, one thing I can tell you is, despite the fact that the statutes haven't changed, insofar as employment cases are concerned, we are lucky or, in a slightly better position because, as Donovan mentioned, the Industrial Court is a court of equity and good conscience. In fact, the Industrial Relations Act itself in Section 30, Sub 5, says that when the court hands down an award, it must do it in accordance with equity and good conscience. And that actually gives the court quite an ambit to be flexible if it wants to. And perhaps I should add, if it is properly convinced, right, not just by the lawyers who are arguing the case, but also the witnesses, how they put forward their evidence, so that the court is swayed, sufficiently convinced that it needs to adjust its thinking or rationale a little bit to fit the situation at hand. Now, we've also heard the terms, closure of business, layoff, retrenchment. So very quickly, when we talk about closure of business, straightforward, okay? It simply means what we in local terms say, bungkus, okay? Company bungkus, no more business, shut down. All right, so was here yesterday, gone tomorrow sort of situation. From employment perspective, what it means for employees is they lose their jobs, and all of them lose their jobs. Now, that's, as I said, very straightforward. What an employer would have to do then is to pay termination benefits, especially if it is for the category of employees who fall within the Employment Act. Sometimes employers may not even have that money to pay, right? If they are really down and out, in which case it becomes an unsecured debt, and there are laws to deal with it. And the employees may get something or they may not get something. Worst case scenario, you even have cases where companies close down and they haven't even paid the last few months' salary. But there are laws to deal with it. Employees may not all get what they want, but it's one of those hard luck cases, right? Business is gone, so that's the way the cookie crumbles. Now, layoff in Malaysian terms means something other than what you ordinarily expect. It's not the colloquial term where when people say layoff, they're thinking about retrenchment, especially in the American, scenario. In Malaysia, layoff actually refers to a situation where a daily paid worker, or rather somebody who doesn't have a fixed salary, but he or she only receives pay for work done. So sometimes we call them daily paid workers, or they call them piece rate employees. So if they don't have work to do, they don't get paid. And this exists in several industries, so you have, some of them are casual workers. Hotel industries have many of these people. So when they have functions and events, then they call these people and say, okay, we have an extra wedding, we need extra servers. Tourism industry as well, especially in Western countries, they have them in the summer period when holidays, everybody's on holiday. So for these people, if they don't receive work for 12 days or more over a span of 4 weeks, 4 consecutive weeks, then they are deemed laid off, because then they don't receive pay, they're deemed laid off, and they are then entitled to layoff benefits, which is the same as termination benefits, the amount, I mean. So then we move on to retrenchment, right? What is a retrenchment? Now, we heard from Dato' Shamsuddin just now, statistics show that at least or more than 50% of businesses in Malaysia are going to need at least 6 months to recover from the impact that this pandemic has had. Now, naturally, in this recovery period, no reasonable-minded businessman is going to just sit down and say, okay, what to do lah, never mind, I pay the salary, I open my office, I pay all my bills as usual. They are going to look at ways to conserve their business. And this is really what business sustainability is. Now, how would they conserve business? Naturally, to look at their big expense item. Now, like it or not, payroll becomes one of the first things that they have to look at. And which is why they naturally move to, however you call it, right? Some people don't like the term retrenchment. So they call it reduction in force, downsizing, right-sizing, whatever. But it means the same thing, right? It means that the business decides that it can make do with less employees. And even the legal term for redundancy is that there is a surplus of workers. So it doesn't mean that you're going out of business like a closure situation. business continues, but you're just trying to make do with less employees than you had before. You know, and the laws surrounding this in Malaysia are very well developed. There are bucket loads of cases on this, and if you were to just go and look it up on the net, you will find so many cases. And interestingly, retrenchment is not limited just to a situation where the company is doing badly. You can have a company that is doing all right, but it just decides to be more efficient. Like when they introduce automation, right? It's not wrong. You know, you don't have some moral obligation to keep 1,000 people in employment when you can actually invest in technology that will do the job, you know, better, faster, more efficiently, and therefore make do with only 700 or 500 employees. And it doesn't just impact manual workers or lower level blue collar workers, because yes, automation, you know, introduced into assembly lines and all that may result in redundancy there. But, you know, if you've read about artificial intelligence, even big time companies like JP Morgan and all that, you know, overnight they made do with 4,000 less lawyers globally, because you don't need lawyers to read through piles of documents. The software will read it and it will flag out all the red flag everything. And then what 4,000 lawyers were doing before, you know, became redundant. Basically, they just became redundant. And the law recognizes that you have a right to manage your business as you deem fit. What is important, however, is that in such a situation, the employees are treated right. And there are, again, a whole set of criteria. One of it is really that the employer should be looking at ways and means to reduce its need for employees. So typically, they shouldn't have been hiring, they shouldn't have had employees working overtime, they should have, where possible, cut back on working hours per day or working days per week. And then, of course, you know, especially where the reason is economic, that the company is not doing well, then naturally the company should first do some cost-cutting measures, right? That's important. So what are the cost-cutting measures? Now, you know, we also heard earlier from Datuk Shamsuddin that businesses were very unhappy when the government said, yes, there's MCO, you can't operate, but you pay salary as usual. Now, what could employers have done during that time is, yes, there was an obligation to pay salary as usual because the contract continues to subsist, but they could have looked at the components of the comp and ben and looked at which ones are actually tied to the fact that the employee needs to be present at a workplace, whether at the office or somewhere else. So, like with my clients, we advise them, look at your transport allowance, right? If it was actually given to them to travel to work or to travel to client site, you may remove it. There are businesses where they even have grooming allowance because these are client-facing people. And if they're not going to work, they don't need to be groomed regardless of what the Ministry of Women's Affairs said, right? So, right? So you can cut back on such allowances. So that is something that businesses should do. Look at your comp and ben, look at the components and see where you can cut back without being unfair. And then, of course, when it comes to selection, who do you select to be retrenched? You know, unfortunately, and all my clients hate it when I tell them this, that it cannot be just somebody you don't like. Okay, I'm sorry. Okay, somebody may have been driving you up the wall, but that's not how it works, right? There is a selection criteria that you have to follow. And this ties to what Shireen presented just now. In the gig economy, it becomes very interesting because when you do the selection, who is your employee and who is not your employee? It's very funny because when it suits the individual, when times are good, they will say, oh, I'm not an employee. You know, I am actually an expert. You know, I'm a consultant. Okay, I'm an independent consultant. I don't work for anyone. Then when their contract is terminated, they'll say, hey, I'm an employee, Okay, how could you have terminated me? You didn't pay me retrenchment benefits, etc. So it becomes important for you to know how to treat these people, right? Are they your employees or are they not your employees? And funnily enough, you find that businesses don't know as well what they should do. They will all tell you, oh, I have this contract, right? It says that he's a consultant, he's an independent contractor. But the contract will say you are entitled to 20 days leave per year. Okay? And it will tell you what you should do if you're sick and you cannot come to work and things like that. So these are the things that you have to consider, and you will realize from how around the world cases have been decided just regards Uber, right? Almost every country, I think, has had to adjudicate, has held Uber drivers are workers. They're not independent contractors. So this is something that you need to look out for. And I know I'm out of time, so I will just say my final piece. And I think that besides the obvious, understanding the law and applying it right and getting the right guidance, you will find that actually when it comes to managing this sort of situation, you just have to, keep in mind that if you deal with common sense, okay, fairness, you will be on the right path. I often tell my clients, who are I will be dealing with the HR manager or the legal manager, and then they will say, no, but we just want to do this, and then I ask them, well, if it was you, what would you think? And then you find them taking 2 steps back and thinking, oh, yeah, well, I guess then it wouldn't be fair, I would be upset, right? And really in the current day and age, it is not just about minimizing your exposure in court, right? It's not about whether you will win or lose in court. I mean, chances are, regardless, if you have good lawyers, you may win in court. But along the way, there can be a lot of reputational damage. And that is sometimes more impactful. If you just lose and you pay, 200,000 or $500,000, it's one thing. But the world is such now, especially the younger batch of consumers, they are very, very particular about corporate accountability. If they find out that there is a business that has treated people badly, it just, like wildfire, it spreads on the web, right? And then there will be all these things like, don't buy this company's products, stop eating this, And do you want to deal with that? So that's why I always say, just approach it all with good sense, fairness, and you'll probably be on the right track. If not, then call your lawyers.
Thank you, Salma, for a very lively and as well as a very informative views for best practices when it comes to retrenchment and looking at what are the better ways to go about it. So in view of time, I'd like to open the floor for questions, right? To the floor for any questions to the fellow panelists. Anyone would like to seek for clarifications, whether with regard to employment, whether with regard to the doctrine of frustration or force majeure, retrenchment, closure of businesses. No? No questions? Good morning. Any? Okay. All right. Mr. Alex.
Okay. Quick question. So, I run an IT firm. So, they all highly paid 6,000, 7,000, etc. Because we're a small company, so to attract the talents, we have to pay high. So let's say we are going to incur a cash flow problem. We want to let go a person who is earning 7,000. How best to terminate? Is it a layoff? How do I go about doing it?
So I presume you are addressing to Ms. Salwa, right? Okay.
Well, so I suppose typically what you're saying is you want to undertake downsizing, right? So you will have to have first done all the other cost-cutting measures that are available to you, cut all non-essential operational expenses, make sure that you said you start, it's your company, so make sure that you are not taking home a big fat director's fees, buying yourself a new car, all these things will, come back to bite you in court. Now, having done all that, the most important thing is selection. In all the cases that I've handled with retrenchment, I tell you this is the biggest headache. And I have many companies, clients that are IT companies. They will tell me, well, we had to retrench X because, even though we had Y and Z who were more junior to him, because the paramount principle is LIFO, last in, first out. So you shouldn't be retrenching someone who's had longer service. But they will all tell me, oh, we did it because, the junior guys, even though they've only worked with us for a short time, they have some special expertise, only they can do this, whereas he couldn't do it. And let me just tell you something, if you're going to approach it that way, you better be able to explain it in a way that your lawyer and the judge can understand. Okay, because for the judge, when you talk about IT, it's about a computer. Okay, and the judge is probably thinking, what's the big deal? This guy has got a degree in computer science, that guy has a degree in computer science, and how can they, all should be able to do the job. Don't come and tell me, I've heard all this, the SAP, the ERP, the everything. So you just have, if you are making that selection, please be very, very sure that when you talk to anybody, whether it's this crowd or in a court of law, they will understand what you're saying and they will be convinced that yes, you selected the right guy for retrenchment. So that's all I can say.
Thank you. Any more questions? If not, I have one. This probably I will address to Donovan. You probably would have read in the papers and in the media about this so-called COVID-19 bill that is actually having been tabled in Parliament. And of course, this bill is also known as the temporary measures for reducing the impact of coronavirus disease 2019. So I just probably like to have Donovan to share his thoughts as to exactly what this COVID-19 bill and how would it likely to impact the employment perspective, right? So,
I think short answer is that there's not much impact to you as an employer or a business owner in terms of the COVID-19 bill that was recently passed by Dewan Rakyat. Datuk has also touched on it a little bit about how that bill, I think, does not really address a lot of the issues that are being faced by employers. So under the bill, for example, there is that codified version of force majeure, which I talked about, where basically the bill said for certain types of contracts, you will not be, the other party cannot sue you, basically, if you are unable to perform your contract during this period due to COVID-19. But there is a schedule to the bill that identifies what type of contracts apply. Employment contracts are not inside. Okay, so the types of contracts that are covered would be things like construction contracts, professional services contracts, but not employment contracts. So on that aspect, employers, you can't say, oh, the COVID bill is not going to let me, get away with not paying my employees because there's a bill now that says I can't be sued for it. So that's a misconception. COVID-19 temporary relief bill doesn't apply to employment contracts. The other aspects of employment that's in the bill is, I think, actually more favorable to, or giving protection more to employees. So it includes things like extending the limitation period for filing unfair dismissal claims. So if your limitation period expired during the MCO and you couldn't go to the IRB and all that, it allows the employees to claim. So that's not really a protection to the employers, unfortunately. There's something about if you're running a private employment agency, then you get an extension of time to file your license, but there's no real reason why only this particular group of companies get that benefit. I think it's mainly to promote job recruitment and all that, but that's really the only benefit if you are in that industry as an employer. So unfortunately, I think we have a lot more to do if we want to have some sort of legislation that really addresses the pain points that Dato was talking about for employees. Thank you.
Thank you. Maybe Dato, you would like to add on to what are your thoughts on the COVID-19 bill?
Yeah, but basically, of course, I would say that we wanted to see more things being addressed within that particular bill, especially on the employers' obligations. But unfortunately, it was not like that. And like what Donovan had said, instead, actually, it give more protection to the employees rather than the employers. So I would say that it is a bit lopsided. And of course, when the government actually come up with this particular bill, they had never had any, I would say, stakeholders meeting over the subject. I know there was one group that actually conducted a webinar on the subject, and at the end of the day, it was submitted to the law minister. But that is, I would say, not a public consultation, because we don't know what actually the government had in mind at that time to what to cover, what not to cover, things like that. So thank you.
All right. So I think our time is up. Thank you everyone for your participation, for your attendance in today's event. Please join me to give a big round of applause to my fellow panelists, Prashant, Donovan, Selva, and Sheree. So thank you very much.